Is how you even got into all this, Dave. You had looked up all the SATs, the SAT scores, and the prayers in school. It was just every day started out with prayer in school.
That's right.
And it was that simple prayer. And then after that, can you talk about that for a second?
What happened was you have the first public school law passed in America, 1647. And from 1647 for over 3 centuries, we had prayer at school, a regular part of what we did. But in 1962, the U.S. Supreme Court for the first time said, time to do something different. You know, since we reversed the meaning of separation of church and state, that now means you can't have prayer at school anymore. Now, I've seen a lot of critics say, well, it's a good thing the court got involved because those poor kids were being forced to pray against their will. That's absolute nonsense. The court itself said that that prayer that they struck down was voluntary and it was non-denominational. Matter of fact, that prayer was that there were 4 major religious groups that came together and said, you know, we all agree on God. And so you had the Orthodox Church, you had the Catholics, you had the Jewish, and you had the Protestants got together and came up with a 22-word prayer. And if you want to say it, fine. It's just a simple acknowledgement. It said, Almighty God, we acknowledge our dependence upon Thee. We beg Thy blessings on us, our parents, our teachers, our country. Simple, bland. Who's going to get offended at that? Well, somebody got offended. They weren't being forced to pray it. Nobody was being forced to pray it. The court said it is voluntary. It's non-denominational. Now, we hear from civil libertarians that the court stopped that coercive prayer. That's nonsense. If you look at every prayer decision the court has delivered since then, there's never been a case of coercion. It's always voluntary. As a matter of fact, in the 1985 case, Wallace versus Jaffrey, the court used that 62 case to say, oh, by the way, you can't even have silent prayer. You're going to wait a minute. And how do they know if I'm praying silently anyway? You know, I've always wondered what the enforcement mechanism is. But the court, this is such nonsense that they're saying it's even unconstitutional for you to voluntarily pray silently. Now, there's no coercion in silent prayer. Nobody can make you pray silently. So we have all these cases. We have the case out of Duncanville schools where you had 10 girls on the basketball team. They were all Christians. They wanted to pray. They got together and prayed. The court said, even though all of you want to pray, you can't do it. It's unconstitutional to have prayer at schools. I mean, these are people desiring to pray, and now you got the court saying, oh no, all school prayer. So that's what happened in 62, 63, was the beginning of the end of any kind of prayer at schools. Even if it's voluntary, even if 100% of the people want it, you can't do it.
John Adams unequivocally declared, if thou shalt not covet and thou shalt not steal were not commandments of heaven, they must be made inviolable precepts in every society before it can be civilized or made free. This was the clear declaration of John Adams. And by the way, I think he'd qualify as an expert on the First Amendment. After all, he personally oversaw its framing in the U.S. Senate, and his signature is one of only 2 that appears at the bottom of the Bill of Rights and the First Amendment. And he forcefully asserts that the 10 Commandments must be fundamental precepts of our civil society. Founding Father James Wilson also affirmed the importance of divine laws such as the 10 Commandments. James Wilson was the distinguished Founding Father who served many years in Independence Hall, signing both the Declaration of Independence and the Constitution, one of only 6 founders to sign both documents. He was then appointed by President George Washington as an original justice on the U.S. Supreme Court, where he served in the court for its first 9 years, including when it met here in this room next door to Independence Hall. Significantly, James Wilson was the founder of the first organized legal training in America. In fact, these law books contain the lectures he delivered to law students here in Philadelphia while simultaneously serving here as a justice on the U.S. Supreme Court. These are really the first American law school textbooks. James Wilson, having helped write the Constitution and then taught students about it, would certainly know what is and is not constitutional. So did he think that divine laws such as the 10 Commandments, must be kept out of public view? Here's what he clearly explained to students. Human law must rest its authority ultimately upon the authority of that law which is divine. Far from being rivals or enemies, religion and law are twin sisters, friends, and mutual assistance. James Wilson certainly did not believe that the 10 Commandments or divine law should be kept from public view. And many other founders made similarly explicit statements. Furthermore, early courts issued literally dozens of rulings citing from the 10 Commandments as a legal authority on numbers of diverse issues. In fact, so clear was the civil recognition of America's reliance on the 10 Commandments that for decades one was more likely to find a copy of the Ten Commandments hanging in a government building than in a religious one. Yet despite this lengthy history of reliance on the Ten Commandments, the court suddenly held that students could no longer see the teachings that are the basis of our laws.
In modern politics, the term separation of church and state is most commonly used to ban acts of faith in the public arena. But a closer look into history reveals the intentions of this phrase to be just the opposite. How then has our history been redefined and rewritten? Discover our nation's godly history in the American Heritage series. America, this is your heritage.
The phrase separation of church and state, where did that come from?
The first time in human history, you got to go back into England in the 1500s. A theologian, Richard Hooker, was the one who used the phrase. He's one of the guys associated with the Reformation. In the Reformation, you've got a lot of the reformers teaching the concept of separation of church and state. They're teaching, look, we got to get the two institutions apart. This thing of having the church and state run each other, of having the church with the sword, and of having the state decide what religious activities, not to be.
Okay.
So they were advocating institutional separation, but then Richard Hooker, theologian, is the first one who used the phrase separation of church and state.
So since that time, the original phrase was used in what year?
The original phrase was used back in the 1500s in England.
Okay, from 1530 to 1947, it was consistent in its meaning?
Consistent in its meaning.
And then it changed in 1947.
We have a completely new meaning, and today Americans think that the current meaning is what it's always been.
Okay, so that just means that we just have people in the wrong places. That the government is filled with misinformed people that we have to change.
Well, this is one of the things that we continue to reteach this myth that goes again and again. It's in our textbooks.
Yeah.
We hear it every time a decision comes down from the Supreme Court, because the court tells us that the Founding Fathers wanted separation of church and state, and therefore you can't have this religious activity. We hear from the court. It's repeated when the press repeats the decisions of the court. You have a lot of secularists who repeat it on a regular basis, and you have very few Americans who know their own history. Quite frankly, we just don't know our own writings.
At the same time they're making those decisions, Congress and Senate have paid chaplains on staff right now.
What has happened, the way the court handles this dichotomy, because on the one hand you're saying it's unconstitutional to have these activities, but on the other hand you're saying, no, wait a minute, these activities were put in by the guys who did the Constitution, so how can it be unconstitutional? So what they've come up with is a historical exclusion. It's what they call ceremonial deism. Ceremonial deism says, you know, in God We Trust, we've had that on coins since back in the Civil War. In God We Trust actually goes back to the national anthem, the fourth stanza of the national anthem back in 1813, 1814. Francis Scott Key wrote that. We've had that in America for 200 years. So how are we going to say that we can strike it down? Oh, I know. Here's what we'll say. We'll say nobody really believes it anymore. It's ceremonial deism, and therefore you can leave it in the coins, you can leave it on the money, because it doesn't mean anything to most people. Oh, I sure appreciate them telling me what I do and don't believe about it. But that's how they excuse it. They say it's ceremonial deism. So things like that, other little phrases that may appear with God in it, they say, oh, nobody really believes that. It's not theological. It's been there for a long time. It's just historical. That's what they do with chaplains. They say, oh, chaplains have been there since the beginning. It's one of those historical traditions that's out there. It doesn't really bother people. People really don't listen to the prayers anyway. So if you want to have a chaplain, it's nonsense the way that they have to come up with exceptions to justify their lunacy in having flipped the First Amendment on its head.